The answer is yes. In the state of Connecticut, and this happened about 20 years ago, what the legislature did is created a rule or a statute in which the court has the right to order parents to pay up to the cost of the University of Connecticut at Storrs, the main UConn campus, up to the cost of their tuition, room, and board. Today, that's approximately $35,000 a year. So a judge has the right to order payment of the two parents combined of up to $35,000 a year. This determination is made usually when a child is in their junior or senior year in college. So if parties get divorced when a child is in elementary school or middle school, the issue isn't decided then. It's decided by looking at the circumstances that both parents are under financially when a child is ready for college. So a court may order, hypothetically, dad to pay $10,000 a year, mom to pay $5,000 a year. They do not have to order up to $35,000. Now, the University of Connecticut at Storrs is the guideline. If your child gets into Yale, the court can only order up to $35,000 total of that $80,000 tuition, room, and board to be paid. A court will look at any funds that are available to a child from either parent before making a determination on how much to order those parents to pay for college. Generally speaking, and in most settlement agreements, parents say, hey, what we'll do is first we'll utilize the existing college funds for our child or children. And when they run out, then the court can make a determination. And by the way, parents can always agree to pay for what they think is appropriate and not go to court to make that determination, which is more often what really happens. The answer is actually no. Unlike our neighboring state, New York, where there are awards of child support and rules for a child who's in college full-time, in Connecticut, child support ends when a child turns the age of 18 and graduates from high school, or turns age 19 even while in high school. So kids certainly cost a lot of money when they come home for Christmas break, summer, Thanksgiving, but child support, the court cannot make an order of child support to a parent. The answer is no. Once a child reaches age 18, parenting plans are gone. It's up to the parents to work things out, or the child to go where he or she really wants to go. So custodial arrangements, those are gone as well. Once a child reaches age 18, they're officially emancipated in the state of Connecticut. If the parties have joint legal custody of a child, which in 98% of the cases they do, that doesn't mean the child lives 50-50 with each parent. It means major decisions concerning their health and education and religion are deemed to be made jointly. So most of the time parents agree and they make that decision together, utilizing the child's input, hopefully, in making that decision. But if there's a disagreement, you can actually go to court and fight over that disagreement. But I can tell you that in that example, and it rarely happens, the court would likely appoint an attorney for the child, which both parents would pay for, and the attorney for the child would probably advise the court what the child wants to do, which, if the child is doing well and seems to have a good head on his or her shoulders, the court will likely order.